Your Lordship, in this case, we have received instruction that the petitioners have been paying the enhanced rent under protest. Your Lordship, may I just be allowed to point out one legal aspect in the matter? Your Lordship, the proceedings were initiated under the Bihar Building Lease Rent Eviction Control Act 1982. The proceedings itself is barred by Section 32 of the Act, which has been considered by a coordinate bench of this court as well.
Which act?
Section 32. Bihar Building Lease Rent and Eviction Control Act 1982.
Yes. Section
32, Your Lordship. It's a small provision. May I please it, Your Lordship?
means that this book is only a commentary.
Yes, Your Lordship. It's a little difficult to find the section itself.
Act not to apply to buildings.
Yes, Your Lordship. Owned by government and trusts. Nothing contained in this act shall apply to a tenant whose landlord is the local authority or the state government or the central government or the Bihar State Shwetambar Jain Trust or Bihar State Vigilance, etc., which may be under the Bihar State Waqf Board Acts. Now, Your Lordship, there was a Bihar Agriculture Produce Market Repealing Act of 2006, in which, Your Lordship, Section 4, it said that once the Act, the Agriculture Market Produce Act was repealed, Section 4 said that assets and liabilities of the board to vest in the state government. So since 2006, Your Lordship, the assets, the buildings are all vested in the state government, and that is why, Your Lordship, Section 32 becomes operational. Considering this, Your Lordship, there's a circular of the state government also, which unfortunately we have not been able to obtain, though we tried, but it has been considered in a coordinate bench decision on this court, in which the state government has accepted the position that Section 32 applies. Therefore, proceedings cannot be initiated under this act. But there seems to be a circular which says that the proceedings have to be initiated under the direction of district magistrate through the Bihar Construction Department. If I may be allowed to just forward this judgment.
But how do you say you are not challenging the proceedings?
We have challenged, Your
Where is
Lordship.
that?
This is a point of law. Your Lordship, you are right. We were going forward on the previous judgment of the High Court, Your Lordship. We had initially primarily relied on that 2010 judgment of the High Court, Your Lordship, which is at page 31. Page 29, Annexure 1A, Your Lordship.
Yes.
In that, Your Lordship, if Your Lordship may come to page 30, this development of the Repeal Act has been considered. Second paragraph, page 30. May I place it, Your Lordship? During the pendency of the writ application, the erstwhile marketing board has been superseded by the aforesaid act, and now the premises are under the control of the state government through the administrator. There has thus been a factual change which may have necessitated fresh policy changes, and for which reason we had thought it prudent to adjourn the matter on 4/5/2010 and again on 17/5/2010. Your Lordship, coming to the last paragraph on the same page, since the present order is ex parte in nature, nothing in this order shall preclude the state authorities administrator from
Where are you reading?
I apologize, Your Lordship. Page 30, last line. Since the present order is ex parte in nature, nothing in this order shall preclude the state authorities administrator from taking any fresh steps action against the petitioners in view of the changed developments on facts. Nonetheless, any such petition with regard to the petitioner shall have to be taken and implemented strictly, but in accordance with, inclusive of, after due notice and consideration of any show cause. Your Lordship, my small submission is that we do not have an issue with the enhanced rent, and we are agreeable to pay the enhanced rent also. But the only issue is, Your Lordship, that in future, if any such proceedings are initiated, they may be done in accordance with law, in accordance with the circular which exists, which is 13/9/2006, Your Lordship. If I may, it's a two-page judgment, Your Lordship, if I may be allowed to pass
See,
it.
so far as what proposed action they may take later on is not what we are asking you, what we are interested in as on today. As on today, you are paying the rent or not?
We are paying the enhanced rent under
You
protest.
continue to pay.
Yes, Your Lordship, no
Till you are
issue.
continuing to pay your rent, they will not evict you.
They may again enhance the rent, Your Lordship.
So
Which they
that
continue
enhancement
to.
can always be done.
Yes, Your Lordship.
That is not barred by
That
this
is not
act.
barred, Your Lordship, but my only concern was, Your Lordship, in case through this order we are agreeable to pay, it may not be subsequently considered by the state that we have agreed on the legal aspect that the way they proceeded against us was correct. That is my only limited concern, Your Lordship. So if Your Lordship may indicate.
We will leave that question open.
And yes, Your Lordship, in the sense that if it may just be indicated that enhanced rent, any enhancement in future will be in accordance with law. There's a circular, Your
Because
Lordship.
if your argument is taken, accepted, then the state will have no remedy left
No, no, Your
for
Lordship.
evicting you.
No, no, Your Lordship, that is not what perhaps I'm not communicating it.
But then,
What I'm saying,
what
Your
is the
Lordship,
provision under which they should?
they have a circular, Your Lordship, which I
Circular
submitted
would
earlier,
not, circular
which
no
lays down the procedure. It is considered in another judgment, which the state has also accepted, which says that it has to be done through the district magistrate. Your Lordship, I do not have a copy of the circular, but the state has accepted it previously. There seems to be a reference of this also in the judgment. If I may just pass it, it's just a one-page judgment, Your Lordship.
But that is not the question before us.
Yes, Your Lordship, but the reason we are not going into those questions also because Your Lordship had asked a very direct, specific question.
That is,
If I may just place it, just one paragraph, Your
we
Lordship.
will not go into that aspect.
So any
We
enhancement
keep it
will be
open.
in accordance with law, Your Lordship.
The petitioner had, by way of district petition, had claimed that the rent of ₹3 per square feet as held by this court in its judgment and order dated 30th June 2010 passed in CWJC 12220 of 92 ought to be adhered to by the respondents. As it has come on record, the rent has been enhanced by the state government by its order dated 30th November 2017 to ₹7 per square feet for the shops situated outside the Bazaar Samiti and ₹6 per square feet situated inside the Bazaar Samiti.
Yes, Your Lordship.
It is also informed that the petitioners who are owning shops at both the places, are paying rent accordingly. Keeping in view the said circular, no, this court holds that the state has the power to enhance rent from time to time.
Yes,
However, the petitioners would be always free to object if the same is excessive.
or not in accordance with law.
The issue whether the rent has been enhanced illegally can also be taken up from time to time by individual owners, public shop holders. Be that as it may, as on today, since the rent is being paid, no further directions need to be passed in the present case. Learned comes for the petitioner submits that the state does not have the authority to invoke the provisions of the Bihar Building Lease, Rent and Eviction Control Act 1982 with reference to the present shops, as the shops are now part of the state property. The issue is left open to be decided in suitable case. Writ petition is disposed of.
It's been decided, Your Lordship, in my humble opinion. Though, Your Lordship, I think in my humble opinion, it's already been decided.
No.
But I'm obliged to you.
So we
For your
agree.
kind consideration.
Remedies, appeal and.
Now cases will be called out individual.
Pardon?
Appeal and revision, my lord, remedy is the
Without jurisdiction.
without jurisdiction of the writ petition, my lord. Appeal and revision before commissioner, my lord. Para 8 I have stated, my lord. This
We are
counter.
not going into that aspect at all.
Yes, ma'am.
They'll continue to pay the rent.
Yes, ma'am.
Item number 35, Mr. Devendra Narayan Singh, and its inaugurated.